Hello, good evening. Hello, Ma'am Jane. Good evening po. Uh, I'm just sharing the events to my Facebook pages. Just give me a second. While waiting for others to join. Again, good evening. This is Nick Caraquel. I will only be staying online for 1 hour because I have other commitment. So just like what we did the last time, if you have some questions, you can just write them down on the comment section below, and I will try my best to answer your questions. Okay, hello. Good evening, everybody. This is Nick Caraquel. I am an immigration attorney based here in Queens, New York. So, as I promised, because medyo na bitin tayo the last time, I'm actually setting up this open topic conversation. So, if you want to ask me questions, just write them down below and we will try to answer them. No? So, again, just a reminder, I will only stay here for 1 hour. And then, sa mga J1 teachers natin or J1 other J1 professionals, I will have a Facebook Live next week. This is about transitioning from J1 to H1B. Anything you want to know about how to transition from J1, what will be the risks, what will be your options, or what will be the timelines, yun yung pag-uusapan natin next week. So stay tuned on that, and we'll talk about that very specific topic on the J1 visas. At the same time too, I'm actually planning to actually do another Facebook Live later this month kasi maraming mga nagtatanong, especially for those J1 teachers whose visa will be expiring in June, and they actually been sending me about the topic of the 240-day work visa extensions, whether or not that would apply for the J1 visa or other visa types. We're gonna talk about that later this month as well. Okay? So, wala pa akong nababasang mga question dito, but I will do that as soon as I see some question. Hello, Sir Janelle. Good evening dyan sa Davao. Hello. So, can you just give me a feedback kung okay lang yung volume ko? Or if it's sketchy or what? Okay? So, may nakikita na tayong mga tanong dito. So, I will just read them as I see them. Okay? So yun, sa isang Facebook user, good evening, just want to ask if it's possible to request an expedited petition for parents. So there are very specific grounds for filing an expedited petition for whether it's for parents, for spouses, for children. And one of them is whether or not the petitioner crimes and calamities, could be one of them, potential significant financial loss, could be one of them, if the health of either the petitioner or the beneficiary is in serious or life-threatening condition, we could also use that as a ground to expedite the case. Now, so again, I believe if you would want to discuss the details of your case, or if you really would want to assess your chance of having that expedited request be approved, I would recommend that you consult a lawyer to discuss the details of your case. Now, just to remind you though that a request is a request until it's approved. You cannot demand it as a matter of right, but again, try your options or take your chance at baka ma-approve yung expedited request mo. So, Azunin, mayong gabi sir, dako ba ang percent na ma-approve ang visa? J2 offenses ko na ay infant? Okay, so I'm not so sure if you're asking about a waiver visa, a waiver or a visa, no? Because a J2 visa is a dependent of a J1. So number one, for as long as the J1 visa holder has a valid visa and it still has an extended validity, then there is a big chance that the J2 will be able to be approved. But you have to be reminded that even if you are a dependent of a J1 visa holder, you still need to prove to the officer at the consular embassy interview that your stay in the United States is temporary, that it is just coterminous with the term of the J1 visa. Ang nangyayari kasi, I would say that 95% of J2 applicants have been approved, and a small portion of that has been denied because during their interview they actually give that impression to the officer that they don't want to go back to their home country. No, they don't have strong ties to the Philippines, and once the officer feels that or has reason to believe that the applicant has no plans of going back to the home country, then it could be denied. So if you could basically give me a follow-up facts, a zoom in on your question, because I don't seem to have all the details I need to specifically answer your question. Princess, any updates on NOS? I don't hear any updates on the NOS. So what we see now, and if I haven't heard anyone who applied for the no objection statement based on having a U.S. citizen child or being married to a U.S. citizen or a green card that has been approved. So as far as I know, the current guidelines from the Philippine EVP is still that it is discretionary for them to, they are accepting applications for no objection statement, but it doesn't mean that if you are married to a U.S. citizen or having a U.S. citizen child, that your application will automatically be approved. So they are still looking for something for them to give a positive decision, but as of now, they haven't been very straightforward as to what that something or extra factor that they are looking at to have your no objection statement approved. But to answer the question, there is no update yet. Rina, I'm a G1 teacher not subject to 212E. My husband is also not subject to 212E residency. He works in IT industry. Last year, his employer sponsored him through EB with approved labor certification. And just this week, na-approve na yung I-140 with pending 485. At napasama po ako sa application niya as dependent. Pwede ko na ba i-drop ang J1 status ko? Since may pending 485 kami or maintain ko pa rin status as a J1. Okay. So, if you there are two aspects of your question, no? So if you're actually asking the question of can I abandon or cancel your J1 visa because you have a pending green card application to be able to maintain status, the answer is yes. But will you be able to work kung wala ka pang work permit? Then the answer is no. So you just have to specify that, because if again I just need to know what the intention of the question is, right? So again, if the intention of the question is for you to be able to maintain status dahil na-file na yung green card mo, can I just actually drop my J1 visa off? Then the answer is yes. But hey, will I be able to still continue to work as whatever your profession is kasi nakapending na yung green card application ko? Then the answer is no. Because in that regard, you still have to wait for your work permit to be able to legally work in the United States. What's the best option po? Extend for 2 more years? I would recommend though, because again, your husband and you being the derivative spouse is being represented by a lawyer. I would recommend that you seek the guidance of that lawyer. As much as I wanted to respond to that question, but I refuse to answer that question because then again, you are represented by another lawyer. Hello, Sir Richard. Kumusta, boss? It was nice talking to you. Hi, Ma'am Jane. Good evening po. If the medical expired and the U.S. Embassy hasn't rescheduled an interview yet, what will happen? So, Ma'am, if the medical exam result has expired and you haven't received the rescheduled interview date, then unfortunately, you have to redo the medical exam before the interview. Sir Nick, mayang gabi. Sir, dako ba ang percent ma-approve ang visa kung na-infant? Okay, I think I answered that question a while ago. I have a tourist visa interview in September this year. Is it fine to get married in US through B2 visa? And which is better to do, AOS and stay after the marriage, or leave the US and apply for a spouse visa? So, again, very interesting question, no? Kasi there is actually a 90-day prohibition rule when you enter the United States and change your plan. But I'll talk about the strategy of I want to have a tourist visa with the intention of getting married in the United States and then apply for a green card. Isa-isahin lang natin. Na? If you want to enter the United States just to be able to get married, but then apply for a spouse visa with the intention of having your interview at the embassy, then walang fraud doon. Pero, pag kunwari, ginamit mo yung tourist visa mo to enter the United States, get married, and then apply for a green card, then that's fraud. So, that's fraud because then again, you are violating the terms of your non-immigrant visa. The other aspect that you need to do though is basically, there is a 90-day prohibition rule for tourist visa holders na pag kunwari, pumasok sila sa US and then they change plan during the first 3 months from their arrival and then get married and apply for green card, then it still is fraud. So I would recommend that you consult with an immigration lawyer to basically do what is right, no? Para hindi lang kayo magkakaproblema. Because it is very expensive to go through the misrepresentation waiver, but there is a waiver, but you don't want to go through that process, though. Okay, Brenda, is it possible for an ESTA holder to adjust after marrying a green card holder? Okay, very good question. No. Just for the information, everybody, ESTA holder are basically for those citizens from certain countries who are not required to have a visa to enter the United States. For example, if you are a national of Australia, you don't need a visa to enter the US. So all you need to do is to apply for an ESTA. So the same manner that American citizens do not need a visa to enter Australia. So basically, yun yung concept na yun. The problem is, once you are using your ESTA, you can only stay in the United States for 3 months and then that visa cannot be extended. So ngayon, there is a 90-day prohibition rule. Now, but I have handled a case like that. So you cannot extend, you will be out of status automatically outside of the 90 days. The only exception to that is if you are married to a U.S. citizen. If you are married to a green card holder, then that exemption will not be applied. So then I would recommend that if you're using an ESTA, you can get married, but still would recommend going out of the U.S. and then apply for your spouse visa interview at the U.S. Embassy abroad. Last June 2016 po namatay ang petitioner ko ang father ko. Ano ang dapat gawin? Ma'am, so first, sincere condolences po though. The general rule is that if the petitioner dies, the petition dies with the petitioner. But there is such thing as humanitarian reinstatement. There are two remedies on that point. If you would be able to show that the primary principal or the derivative beneficiary was in the U.S. at the time of the death of the petitioner, then your chance of approval is around 95%. You just have to provide some requirements, and one of them is to find a co-sponsor. It's a different story when the beneficiary, all of the beneficiary or derivative beneficiaries are outside the United States when the petitioner died. In that case, winning a humanitarian reinstatement argument at the U.S. Embassy level is very, very high. But then again, there is still a chance, right? I would recommend that you consult with a lawyer to really know what your chance and if it's worth it, because medyo may kamahalan din. Again, any type of cases that requires a waiver will be a little bit expensive because, again, the lawyer's time will be more devoted to your case and it takes much of his resources though. But good luck on that. Attorney, pag H4 visa holder po ba, hindi pa rin pwede mag-work? Generally speaking, if you are an H4, you cannot work. There are proposals that the H4 beneficiaries will be able to work, but that has been rejected several times. So as we speak now, there is no, H4 visa holders are not allowed to work. However, there is an exception. If your H1 visa holder is already towards the 6th year term of their H1 visa and there is a pending green card application for them, that has been there or pending for 6 months, then you may be able to apply for a work permit while waiting for the H-1B approval. So yun lang yung exception na yun for you to be able to work. How to jump from J1 to H1B and thus H1B is a way to citizenship. Yun po yung topic natin next week. So, Facebook user, please watch that next week. So, we could specifically talk about that topic. Okay. Manjing, if the beneficiary isn't ready for the interview yet, what will happen to the case? Will it be abandoned or there is a grace period? So, ma'am, for as long as you communicate with the NVC or the embassy for 1 year, your case can stay at the NVC or embassy for 1 year. So, the key here is that you continue to communicate with the embassy or the NVC para ongoing pa rin yung case mo. Because yun lang yung rule doon na para hindi ma-abandon yung case mo, just continue with the communication with either of those two agencies kung saan nakapending yung case nyo. Okay? Little girl, may I ask po help about sa AED ng husband ko? His work permit. AED is the Employment Authorization card na ina-apply. Will expire on April 15. If we apply for a renewal so that he can still work up to the last day ng end ng visa po namin, can he still be approved by USCIS? So, una, you will be running out of time. So, again, depende kung saan galing yung AED mo, no? Kasi kunwari, again, I don't know if the AED is coming from a pending petition, green card application, or from some other visa types. So, yung sinasabi ko kanina na I will be talking about the 240-day extension of a work permit if your visa has been timely filed, then there is a 6-month extension. But again, I would rather want you to wait for that because that is not, it's a lengthy process of the conversation. No, but we have cases where if you could actually successfully argue that you need your work permit because you will suffer potential significant financial loss or for potential severe hardship, then you might be lucky to have your work permit expedited ang approval. So, again, if you would want to know the details of that, I would recommend that you would consult a lawyer. Sir Nick, pila ka years po maka-petition ang US citizen nga mother sa married nga mga anak? Okay, so petition for married children by a US citizen parent actually takes now about between 10 to 15 years. No? Though, the good thing about that though is it changes every month with the visa bulletin, but as we speak now, nandun sa range na yon ang waiting period ng married children by US citizens. So, yung category na yan is the F3 or F1. Naso, sir. Give me a second. Sagutin ko lang yung category na married children of a US citizen. Okay, yeah, F3. Married sons and daughters of US citizens. So, if you actually get to search the visa bulletin online, then look for the table A and tingnan mo kung anong dates na nakalagay under the Philippine column, then across F3. So, if your case has been filed on or earlier that date, then your case is already current. And then you will be expecting your case to be processed by the NVC or the embassy. Vilma, how long po mag-response on USS RFE? They receive already RFE response. So generally though, once you actually respond to the RFE, it could actually take a month to 3 months for them to respond. There are cases where we receive a decision right away, but with the pandemic now, it's taking a while, no? For some, again, 1 month, but especially for the waiver cases, it's now taking months for them to review and make a decision. So again, the pandemic has really changed a lot as far as immigration processes are concerned. So just be patient with that. Do you need to have a valid status when you file a spouse visa? What if the J2 get married? Can a spouse immediately file for it and no need to renew the J2? Okay, so depende kung anong immigration status or the immigration status ng petitioner, right? Because if the petitioner is a US citizen, yes, they can file the spouse visa and apply for the green card right away, no? And then kung hindi na nila i-renew yung J2, it's okay because then the filing of the green card application keeps your lawful status in the United States. However, if you are married to a green card holder, then hindi immediately available ang visa na ang ano na yon, ang number na yon, but glad to say na yung F2A category, the spouses and unmarried children of a green card holder is still current as of the current visa bulletin. It only means that pag nag-asawa ka ng green card holder, you can now file your green card application right away. So for as long as the J2 is still in status, they can file concurrently their spouse visa application and the green card application, right? So yung question mo kasi dito, what if the J2 get married? Can a spouse immediately file for it? Sa current visa bulletin, yes, but it doesn't apply all the time. So I just want to make sure that people who are actually watching this Facebook Live, na hindi nila sasabihin na pag you are married to a green card holder, automatic pwede ka na mag-apply ng green card, right? Because you really have to check the status of the F2A under the visa bulletin. If it shows current, then yes, you can apply for the spouse visa and the green card application right away. But if that column is not current, then you cannot file the green card, but you may be able to file the spouse visa portion of it. So again, for better guidance, I would recommend that you consult a lawyer for more detailed conversation. Mary Grace, for example, natapos na yung 3-year initial H-1B, tapos nag-offer sa employer ng 3-year H-1B extension sponsorship, what is the best time to apply for the green card? The good thing about the H-1 visa though is the dual intent. Even it means that even pagpasok mo H-1 ka and the employer wants to file the green card application for you because they already have an approved labor certification, then there is really no timeline as to when you need to wait. But para na mas maintindihan ng iba na bakit some employers are willing to file the green card application right after nakuha ng aplikante yung H-1B, and why is it that some employers wait for 3 years or 5 years before they will offer the green card to their employees? So it's actually more on the practical side of the employer, especially if there are investments, no? Because for H-1B, the employer is required to pay for all the processing fees on H-1B, and it is not cheap, no? It is expensive, depending on what firm or law offices actually handles the H-1B. No, so kung ako yung employer, why would I spend another thousands of dollars na kung kakukuha ko lang ng H-1B to file the green card application, no? Especially for employers who are in the remote areas, because their sad story is that once their applicant or employees already obtain the green card, then that employee will leave them because they would want to be in the bigger cities and so on. So, ang ginagawa ng employer is they would want to maximize the term of the H-1B, which is maximum of 6 years. Initially, they are given 3 years. Then after that, it can be extended for 1 year. 1 year, again, depende kung dito papasok ngayon ang policy ng company kung anong gusto nilang gawin. There are companies who would actually have the policy na, no, we are not going to apply for your green card until you reach the 5th year. But at that point, meron na silang approved labor certification so that they could file the green card right away. No? But to answer your question, what is the best time to apply? It really depends on what the employer offers to you. No? So if they want to offer that after you get the renewed H-1B, or they're gonna wait for your 5th year, 6th year, is really as a matter of policy. What I would recommend is that you communicate with your HR and actually convince them to file your green card as soon as time possible. Tata, if ever I go to US with my husband and son, is it okay to go even if I haven't changed my surname yet to my husband's last name? I have a marriage contract to show. Yeah, wala namang requirement that if you are married, that you are going to change your last name to that of your husband's last name. No? But be ready to answer questions from the officer if they would want to know, hey, you are already married, why are you not changing your name? Then you can just explain why you didn't change your name yet. Again, there is no requirement for you to change your name. It's your choice. If you want to keep your maiden name or you want to adopt your husband's last name, and then you would be able to show that, hey, this is my marriage certificate or marriage license, I don't want to change my name, it's okay. You should not have a problem entering the United States. Christine. Ay, hello Ma'am Christine. Long time no talk. Okay. Posible po ba na ma-approve ang pag-apply kami ng H-2B para sa brother ko for my pallet business? Po kami gusto sana namin. Okay, so ma'am, good news is the H-2B visa or the Philippines has been reinstored to be an eligible country for the H-2B. The problem though is puno na ang H-2B 2022. So your best chance is to apply for the H-2B 2023. No? So if I would recommend that if your employer is planning to hire, if you are planning to hire H-2Bs for 2023, dapat ma'am simulan na niyo process second quarter this year, no? The soonest time possible. Kasi lottery na rin yung H-2B ngayon, just like the H-1B. And it's a little bit complicated process. I would recommend ma'am na magpatulong kayo sa immigration lawyer to go through the H-2B process as much as possible, no? And then, since you are trying to petition a relative, there are extra documentation and efforts to show that you are not favoring your relative over other applicants for your H-2B visa. But good luck on that one. Maxell, is it true that if you are continuing J1 participant, when you go to the Philippines, you don't need to undergo visa interview again? Since the visa stamp has expired already. Okay. Is it true that if you're a continuing J1 visa applicant, we go home, hindi na ba daw kailangang mag-appear for sa embassy? Wrong po. Right? Because the purpose of a visa, a valid visa, is yun yung document to show to the officer that, hey, I am authorized to enter the United States. Ngayon, just in context lang, para maintindihan ng mga hindi J1 visa holder. So, normally, they come to the United States, they are given 3 years initial stay, and then, after that, they were extended to 2 years, but yung tatak na visa on their passport has already been expired. But they are still maintaining status in the US because they were given an extra 2 years dun sa DS 2019 nila. Ngayon, lalabas sila ng United States. Anong gagamitin nila ngayon pagpasok dahil expired na yung visa stamp, no? You cannot use the extended DS 2019 because a DS 2019 is not a visa. So in that case, wala ka talagang choice kundi dadaan sa embassy for visa stamping interview. In those cases, the officer will still ask you about, hey, how was it your first 3 years and did you really work with your employer and if you have not violated the terms of your J1 visa. So the chance of being approved, let's say, nasa 98%, but there are still cases who got denied because some of them actually violated the terms of their J1 visa. But to answer your question, ma'am, hindi po. Kailangan ka talagang dadaan sa embassy to have your visa updated para yun yung gagamitin mo to re-enter the United States. Attorney, if a family is staying in the US under B1, B2, then my employer willing to sponsor one of them, can they process working visa while in the US and will dependents be included? So, generally speaking, so ang sinabi ko kanina na mayroong 90-day rule, no? Because people come to the US to use using the tourist visa to enjoy the United States or to have temporary transactions, business transaction, or attend conferences and so on. So, in any case, it should be temporary. The problem is, if they change their mind because they now want to stay longer in the United States, within the first 3 months of their arrival, then magkakaproblema ka doon because you might fall into the fraud finding if you do it within the 90 days. But let us just say, for purposes of conversation, after the 3rd month that there is a compelling reason for you to change your plan, and then nag-apply ka ng student visa or you were actually offered an immigrant visa through employment, is it allowed? Yeah, but you just have to be prepared. Kung halimbawa nag-apply ka ng green card, to be prepared at the time of the interview, what triggered the change of plan or whether or not yung pag-apply mo ba ng green card nung pumasok ka sa US, was it pre-planned? because that's where the officer really want to know the intention when you enter the US on the B2 visa. But if the officer finds out that the initial intention was really just to come to the US for temporary visit, but for whatever reason, nag-change yung plan mo and you got lucky, you got an employment offer, and then yung employer mo nag-offer sa iyo ng green card, then you should be okay. Second question, will dependents be included? Yes. The spouses will be included in that green card application, as well as any children, unmarried children below 21 years old at the time of green card filing. So what would be the status if the J2 is not renewed? Okay, so I need to know where the J2 visa holder is. So if the J2 is in the United States and hindi na approve renewal, then they will be out of status, no? But I seldom hear stories daw na hindi na approve yung renewal ng J2 for as long as they are below 21 years old and they're still within the parental control of their parents, no? So but halimbawa, if your J2 applied for interview at the embassy outside the United States, and for whatever reason the officer denied their application because, oh, you don't have strong ties in your home country, then they don't have a visa, no? But can they try again? Maybe. But yung finding na yon na they were denied because they have no strong ties, nandun pa rin yung record na yon. So, ma'am, if I didn't answer that question because I need more information about that, if you can just give more information. But generally, to answer your question, if the J2 visa is not renewed and if the applicant is in the United States, then that person is already out of status, right? Ngayon, pag nasa labas yung J2, then they did not get the J2 visa status. So then they cannot enter the United States. EB3 visa takes 2 to 3 years processing, correct? Kailan mag-start ang counting ng 2 to 3 years from the day you submit your application or from the day na may employer na? Okay, so yung sinasabi mo na EB3 visa, then we are not talking about the nurses and the PTs, no? So we are talking about all other professions who would want to petition foreigners outside the United States or inside the United States, but ito yung tinatawag natin na perm process, or the ultimate goal is to have a labor certification approved. So that process is an employer-owned process. So when do you start doing that? The first step of that process is to apply for the prevailing wage determination. So hindi ka talaga magka-count ng 3 years, but it's basically that process may take 3 years. And the first step of that is when your potential employer files the first step. And the first step is the prevailing wage determination, or the PWD. So once the PWD is filed, that's when you start counting the potential 2 to 3 years. No? So again, hindi siya yung activity dependent on the applicant, but is actually a process that is dependent on the employer kung kailan sila nag-start mag-file ng prevailing wage. Doc, Alan, kumusta? Boss, pakita ka naman, boss. We haven't seen each other for, I think, 2 years na. Ingat. Susan Parilla, Sinik, as a green card holder, pila ka years waiting sa husband and anak to petition. Okay, so ma'am, spouses and unmarried minor children of a green card holder normally takes about 2 years kung you are in the United States, right? Because current nga ang visa bulletin of the F2A category. The problem is, pagdating sa embassy, even if your petition has been approved less than 2 years, in Manila, because of the COVID situation, they didn't give priority for those category. No, this has been efforts to actually petition the embassy to schedule spouses and children of green card holders. Very limited lang talaga ang nakikita mong schedule. It's a limitation based on the embassy prioritization. The lawyer has nothing to do with that, or the applicant has nothing to do with that. It's the category, and the embassy has not been giving priority to those, no? But we've seen that category, spouses of green card holders or children of green card holders, being processed faster outside Manila, but in Manila, medyo hindi masyadong gumagalaw. Wishy Caps, what if kaka-reinstate lang ng J1 kasi na inactive dahil sa application ng H1B? Magkaka-extension? Okay. So, it really depends on the J1 sponsor, no? Because ganito yon. The J1 sponsor's job is to secure that applicants and employers protect the J1 program. What does that mean? That when they actually sign that contract, the applicant and the employer commits that after 5 years, in some cases 6th year, 7th year because of the pandemic, that the applicant needs to go back to their home country. Ngayon, any change of visa, whether nag-J1 ka to tourist, J1 to student, or J1 to H1B, is a red flag signal to the J1 sponsor. It means you have the intention of not honoring your commitment to go back to your home country. Then they might deny you applying the extension, no? Because the J1 sponsor is so powerful and it's within their jurisdiction to not extend you or to not process the extension per se. But we also heard some sponsors who have been lucky to accept, but again, that's not within the terms of their commitment, no? Because the commitment of the J1 sponsor is to protect the J1 program, and it means that they should put all the efforts that all applicants should go back to their home country when the J1 visa program expires. The moment that if for some cases, pag kunwari malaman lang nila na nabuntis yung J1 sponsor, kinakancel na nila yung J1 eh. No? The moment na malaman nila na you got a US citizen child, they could also cancel your visa. If they know that you are married to a green card holder or a US citizen, they can also cancel a visa. Much more if they would learn that the applicant applies for another visa type. So, but then again, I'm hoping that they will still be able to file your extension, but generally speaking, any change of visa would be a ground to not extend the J1 visa. I hope I answered that question. Jing, if a beneficiary had her green card for 2 years already, can she possibly file a divorce that already after all she has 10 years? Okay, so how do I say this, no? So, ma'am, I would presume, no, na when you actually obtained the green card, there was a good faith marriage, and that's the reason why. So, I am assuming that you got the green card through family-based petition, no? So, there was a good faith relationship. Ngayon, it's not impossible that there are some relations that didn't work, and then they decide to get divorced, even 1 month after, or 2 months after, or 3 years later, no? That after you got your green card. Now, if your green card is 2 years, then you need to go through the removal of condition, now where you still need to prove to the government that after you get your green card, 2 years later, you are still married to that U.S. citizen or green card holder spouse. But for whatever reason, you already got divorced. You still need to prove that, yeah, the marriage was entered into good faith, and then you have documentation to show that, hey, you have intended to live together as husband and wives. If you will be able to be successful in that, chances are you will get the renewal of your 2-year green card. Now, what if yung green card mo 10 years na, no, and then nag-divorce ka? Then you are in a better position because you don't have to prove to the government that kasi paano ba nakuha yung 10-year green card? Nakuha mo yung 10-year green card because by the time that it was issued, you are already married to the petitioner, whether green card holder yon or US citizen yon, more than 2 years. So, if, let's say nga, nakuha mo yung 10-year green card mo, 1 day later, you file divorce because the relationship didn't work out, it only means that you have to wait 5 years from the time of your green card issuance to be eligible for citizenship. Okay? So, careful lang doon, ma'am, no? Kasi inunahan na kita doon sa tanong mo, no? Kasi balikan ko nga, correct? Na the beneficiary a green card for 2 years already, can she possibly file a divorce? Yes. Filing a divorce, wala naman problema yon. The next question kasi doon is, will I be able to renew my green card kung 2 years lang siya? Or will I qualify for citizenship after 5 years if nakuha nila yung 10-year green card? So, in either of those applications, with the removal of condition or citizenship, the officer may still look into paano mo nakuha yung green card mo, and they may still, if it's based on marriage, they may still inquire into the good faith relationship documentation, no? But in most cases, if you apply for 5 years, the inquiry of the officer is only whether or not you maintain physical presence in the United States for the last 5 years. But to simplify the whole conversation, ma'am, tawag ka na lang, ma'am, no? Para mas ma-discuss natin yung case mo. XC, if a family is in the US under B2, ang daming mga tourists nanonood ngayon, okay? Then my US employee is willing to sponsor weekend visa. Can they process it while in the US and will dependents be included? I think I answered this question a while ago now. So again, if you are in the United States, can the employer start the green card application? Yes. But will the tourist visa holder be able to stay in the United States without changing a different type of visa? No, malabo. Kasi if you enter into the United States on a tourist visa, you are only given 6 months. Now, by procedure, you are allowed to extend another 6 months. So maximum, 1 year lang yon. No, but filing a green card application could take 2 to 3 years. So normally, yung mga tao na yon would file for a change of status to a student visa so they could basically stay in the United States lawfully while waiting for their visa to be approved. No? But to answer the question, can they process it while in the United States? Yes, but be careful with that. Will the independents be included? Yes. For spouses, automatic yon. For children, it has to be unmarried and below 21. Ilan buwan validity ng visa? So normally, ma'am, generally it's 6 months, no? But for some cases na nag-sputum, it only is valid for 2 months. And the problem is you have to have the visa issued while the medical exam result is still valid. No? Else, magpaparenew ka talaga or magpapare-exam ka talaga before the next interview date. Maxwell, is it true that if you are contingency 1, okay. Wishi, kung hindi makaprovide ng RFE on a given time frame sa US, anong mangyari sa approval notice ng H-1B sa employee? Kung hindi makaprovide ng RFE. Okay, so I'm not so sure if I understand the question though. So, hindi makaprovide, so I would presume that you have the RFE and you will not be able to comply with the RFE. Then that means that whatever that application will be denied, no? But if you already have an H-1B approved, and again, I'm holding myself not to be able to explain the details of your case. Ganito kasi yun, ma'am, no? There are people who actually obtain an H-1B. So, kunwari, nag-tourist visa sila dito, no? So, then somebody filed an H-1B petition for them. Then they apply for a change of status from tourist to H-1B. Ngayon, na-approve yung H-1B. But USCIS says, but I did not approve your change of status application. So, dininay niya yon. Pero, yung H-1B application mo was approved and it was valid for 3 years. So, ano bang ibig sabihin nun? Ang ibig sabihin lang nun is hindi ka pinayagan ng US government na mag-change ka from tourist to H-1B. And normally, what the government would do is forward your approved H-1B to the embassy. So what does that mean? Kailangan mong lumabas at mag-apply ng interview sa embassy and gamit yung H-1B mo. Right? So hindi USCIS ang magbibigay sa iyo ng visa, but it will be the embassy. So again, for people who are not familiar with this H-1B change status being denied and so on, it sounds complicated, but that's the only logical explanation to answer your question. No? So to answer the question, pag yung change of status na in-apply mo dahil hindi mo ma-provide yung RFE, no? And this is very common for J1 teachers na nag-apply ng change status from J1 to H1B, no? And they are subject to the 212E. Ngayon, the normal RFE requirements hinihingi nila is yung waiver. Kung hindi nila ma-provide yung waiver na yon, so it means the change of status application will be denied. Does that mean that the H-1B has already also been denied? No. The H-1B stays as being approved and normally 3 years ang validity nun. It only means that the applicant needs to go out of the US, apply for interview at the embassy. So again, I'm talking about J1 teachers subject to the 212E. Ibig bang sabihin nun, pag uwi nila sa Pilipinas, they can schedule an interview at the embassy right away? No, kasi kung subject sila sa 2 years, kahit mag-schedule sila sa embassy, i-deny rin sila. Kasi nga, they still need to stay for 2 years in their home country. Eh, kung 3 years validity yung H1, they can use the same approved H1B after 2 years. Yan yung ibig sabihin nun, no? So, I hope I was able to illustrate it. Lilibet, pwede po ba ma-change ang status from H1B or permanent resident ang J2 visa holder? Okay. Yes, pero yun yung topic natin next week, no? The J1 transition from J1 to H1B to green card. Please hold on that next week. Okay, paano po natapos na ang H1B visa mo? Pwede bang lumipat ng employer para di na umuwi ng 1 year sa Pinas? Okay. Paano po kung natapos mo na ang H1B visa mo? Pwede po bang lumipat ng employer para di na umuwi ng 1 year? I would presume na ang question na to is from somebody who have maxed out the 6-year term of the H1B visa. No. Kasi as a H1B visa holder, you are only allowed to stay in the United States maximum of 6 years. So, then, your employer should decide whether ipa-file ka ng green card o hindi. So, normally, how we do it though is when we are handling with the employer na marami silang H1B or even single H1B visa holder and then papunta na sila doon sa 4th year, 5th year. Or even those school districts that we've assisted na nakakakuha sila ng 3-year initial H1B validity. We recommend that kung hindi pa sila nakapag-start ng labor certification, that they have to start the green card application the moment that the H1B visa holder arrive in the United States para ma-avoid na namin yung renewal ng H1B. Okay? Pero to answer your question, umabot siya dun sa 6 years. Hindi siya final ng employer niya ng green card application. Then to answer your question, yes, that H1B person needs to go out of the United States, stay outside for 1 year before he or she can apply for another H1B or apply for a green card application. It's the limitation of the H1B. Pwede po ba ang exception? We'll talk about J1 waivers next week. Daisy, my sister's mother-in-law is a US citizen. I'm a J1 visa holder and my family is also here. Can she petition or sponsor us? What kind of visa? My sister's mother-in-law is a US citizen. Ma'am, hindi po. No? So, only immediate relatives can file a petition to a direct beneficiary. So, ibig sabihin, in-laws cannot file a petition for their in-laws, right? So, or the other relative by consanguinity or by affinity, no? So, ibig sabihin lang nun, only mother, father can file a direct petition to their children or vice versa, or siblings, but the other relatives cannot do that. So to answer your question, no, they cannot. Sir Randy, is IJA waiver now allowed for J1 teachers? No, hindi pa rin, no. But there are reports that we are lobbying either the Indian school district, the Indian education government governing body, or we are actually working with some representatives to actually lobby for the IJA, but to answer the question, no. The IJA, the interested government agency, is still not available for teachers as a ground for the waiver. Christine, isa pa po, nag-apply po kami ng extension of stay ni mother ko, pero umuwi na siya sa Pilipinas, hindi na nakapag-biometric ng pwede pa siya mabalik? Yes, ma'am. Pag kunwari, yung mga tourist visa holder, na pumasok dito, they were given 6 months normally, and then they decided to extend, and then nag-file sila ng another 6 months extension. But for whatever reason, hindi na nila hinintay yung approval or denial ng application na yon, but they left the United States. So what will happen then? So then that extension will be denied by reason of abandonment, but that visa holder can still come back to the United States. They might be a question at the port of entry, bakit nga iniwanan yung o inabandon niya yung extension na yan. And they will still be able to come in, no? In some cases, their stay may be shortened. So, kasi binigyan kita ng 6 months last time, nag-apply ng extension, hindi mo tinupad yon, then maybe you will be given only 1 month, 3 months, no? But to answer the question, yes, makakabalik pa siya dito. Is there a chance po ba that J1 visa holder granted a green card? Okay, green card. That question will be discussed next week. When I apply for K1 and K2 to bring the future wife and kids to the US, does she need permission from the biological father to bring the kids? Okay. So if the biological father signed the birth certificate of the children and they were legally terminated because hindi ka naman pwedeng mag-file, you cannot file for a fiancé if the fiancé is still married, no? But I'm just looking at the possibility na, she was formerly married and they have children but obtained annulment or nullity of marriage, and now somebody filed a petition for them, and then the father signed the birth certificate because they were legally married before, then the biological father has all the rights to object to bringing the children to the United States. But however, the most cases kasi ng mga fiancé visa holder with children, hindi kasal do sa father ng kanilang mga anak. So, even if the father signed the birth certificate, there is no legal requirement to ask for their permission to be able to bring the child to the United States. So, again, you might have heard to get permission from the DSWD. That is not necessarily true. For as long as they are not married, the children are illegitimate, then you would be able to bring the children to the United States without permission from the biological father. Kailan po ba ang safest time to apply J1 waiver? Next week po. Pag-uusap tayo. Can a J2 apply for student visa if they are subject to the 212E? No. If they are not subject to the 212E, yes. Jai. Ask ko lang po, may ibang way po ba makapunta dito BF ko kahit na may case daw siya before and his younger time called felony? Last March, pumunta siya dito para magkita kami at makafile ng fiancé visa pero naharang siya sa NAIA. Okay. So, ma'am, when foreigners, in this case, Americans, being held at the airport in the Philippines, it means na yung case na yon hindi lang yung basta-basta felony, mama. It's actually more related to the sexual side of the offense. So, ang tanong mo ngayon is, may ibang way po ba na makapunta dito, BF? I would really recommend, ma'am, that you consult with a lawyer because I've handled cases where the petitioner have criminal records, but we were able to successfully bring the spouse or the fiancé over to the United States, right? But then again, if the felony pertains to sexual offenses, then it becomes a harder case because it is more on the Adam Walsh category, and that particular case is difficult. What is the chance of approval? Depending if they will be able to show that that person has already been reformed and is no longer a danger to the person he or she is petitioning. Okay? Okay, is my father in danger? I see. When he misrepresented that he was single when in fact he was married in the Philippines, but now he's already a U.S. citizen for a very long time, maybe 30 years or more. Can he be reported to USCIS? To answer the question, yes. As a matter of fact, there are 50,000 denaturalization cases kasi very common yan in the Philippines before no? Na dahil sobrang tagal ng paghihintay, pag ang anak ng US citizen is married, ang ginagawa nila, they misrepresent themselves to show, hey, I am not married, I am single, kasi nga mas mabilis yung pagpasok ng mga unmarried children of US citizens or green card holders at that time. But that was the time when technology is not that amazing, no? But ngayon, they were catching up and they will be able to trace that, hey, you were actually not, you are married, but you changed and there was fraud. The question is, can they be reported? Yes. Will the USCIS aggressively run after them? I would not say aggressively, but maybe sometime, no? But it's been 30 years, right? Careful lang, ma'am, kasi pwede talaga siyang i-report, no? Because that's still fraud. And in cases like that, the embassy, the USCIS would send them letters to say, you have been in denaturalization proceedings because you are not entitled to the green card in the first place. Okay, so we have 6 minutes, but marami-rami pa to. I might be able to extend 15 minutes. So, magtanong na lang, no? So, we have about 20 minutes left. Pila ka months or years makakuha ang visa interview appointment at J2? I don't know, ma'am, to be honest. You have to check on the visa embassy because you have to go through your US travel account and then choose the right category and see what's available dates at the US Embassy Manila nowadays. Ma'am Wishi, I really recommend, ma'am, because again, I know your case, right? I don't want to have to be in danger of speaking too much about your case. Paset na lang ng interview, ma'am, so we can talk about your case. Rina, gaano po katagal ang approval years from J1 to F1? Okay, I presume, ma'am, Rina, no, na you are not subject to the 212E. Again, even if you are applying from B1, tourist visa to student, or J1 to student, the processing time normally now is 9 months to a year. So, the good thing about that, though, is binago nila yung policy, di ba dati? Pag tourist visa holder ka, you need to renew and renew every 6 months. But they recognize that it's the pandemic, people have no money. So, isang extension lang, okay ka na. So, pag J1 ka naman, walang requirement na gano'n because you cannot extend the J1 while waiting for your F1. But to answer your question, it takes about 9 months to a year to wait for their decision. Ay, Ma'am Malin, kumusta? Long time no see, ma'am. Pwede po ba ang father-in-law ko maging employer ng kapatid ko? Interesado ang father-in-law ko na matulungan ang kapatid ko na sa university nag-work ang father-in-law. So, ma'am, I would just answer the question generally speaking, no? Wala namang complete prohibition filing petitions for relatives. Though there is an extra requirement for the government to show to the government na walang favoritism when the employer choose the potential beneficiary. No. But this takes a lot of time to explain. Una, when a petitioner file a petition for a foreign national, there's two things that they need to to show. Number one, that there is a legitimate job offer. So, ibig sabihin, may business ako or may personal needs ako and I need somebody to do it for me. Number one. Number two is that the petitioner has the ability to pay. So, again, if they would be able to show that they have money in the bank to be able to pay the prevailing wage, then that would be enough for the employer to file a petition for a foreign worker. Second, once you pass that, yun yung tinatawag na natin na labor certification process. For the employer to prove that, hey, I have a need and I have advertised it and there is no U.S. citizen or green card holder available and willing to do the job. So that's the first step. Once that labor certification is approved, then the inquiry goes into the applicant. Thus, the applicant has the formal education, training, and experience to be able to do the job. No? So doon ngayon, ang tanong, is your brother eligible to the job offer? So I'll give you an example. Now, if ang employer naghahanap ng caregiver, so ang tanong na lang ngayon, yung brother mo ba has the formal education to be a caregiver? Does he have at least 2 years experience as a caregiver? Then, if the answer is yes to those questions, then he may have a chance. The next challenge na lang doon is kung dalawa ang nag-apply at mas qualified yung isa, then the lawyer should be able to actually find ways avoiding the favoritism argument ng USCIS. G, I said Francis po, hope you can assist on that. Okay, ma'am. What will happen if the visa sponsor would process the 2-year extension of J1? Naka-J1 transfer to another J1 visa sponsor. So, I would presume that you're already on the 3rd year, no? So, can you transfer to another J1 visa sponsor who is willing to file your another 2 years? Yes. Is it advisable? No. Because if you are already subject to the 212E, yun nga sinasabi natin, no, na when you have the 3 years J1 visa, you are under certain program that would restrict you from getting another H1 or immigrant visa because you need to go back to your home country for 2 years. Ngayon, for purposes of argument, nag-apply ka ng ibang J1 sponsor at binigyan ka ng 2 years. That is another program. And if that program will subject you to another 2 years, then 4 years na tuloy yung magiging restriction mo. So, again, ma'am, to answer the question, is it possible? Yes. It is advisable? No. No? I would recommend that you consult with a lawyer if you need to discuss the details of that. Hi, VJ. Kumusta po, boss? How's North Dakota? Genesis, kailan po ang safe application for a J1 waiver? Let's talk about that next week, boss. Hello, Ma'am Maricel. How's Missouri? Since I'm not citizen yet, can petition my parent, can able my husband to, no. Ma'am, you have to be a US citizen to be able to petition parents. But you might want to take the chance of your parents apply for a tourist visa. Malay mo ma'am, ma-approve sila, no? But to answer the question, no. You need to be a US citizen to petition parents, and no, your husband cannot petition the parents. Zale, Atty, just want to ask po regarding petitioning our son. He will be turning 18 this August and we are planning to file the petition in the next few months. And for sure, hindi na siya makaabot ng dito sa US before he turns 18. Will he still be eligible for automatic citizenship if he enters the US after he turns 18? Okay, very good question, boss. No? Yung 18 requirement kasi is that for the child to be able to derive US citizenship automatically, it only means that the child was below 18 when the parent becomes a US citizen. So, ibig sabihin, I would presume na hindi nga 18, below 18 nga yung anak mo na when you become a US citizen. Even if pumasok siya, boss, at 19 years old or 20 years old, pagpasok niya, entitled pa rin siya ng derivative citizenship. No? Again, there might be complexity in terms of presenting your case kasi nga above 18 na siya when you file the application, but it can be done that he could still apply for derivative citizenship because he was below 18 when the parent becomes a US citizen. Cindy, is there any chance of processing the spouse visa? Of course, right? Especially ngayon, na current ang spouses of a green card holder. So again, if your spouse is a US citizen or a green card holder, yes, you can process your spouse visa nowadays. Sir Ricky, good evening po. Michelle, can a US citizen petition for a green card to a stepfather? Yes, provided that the stepdad and the biological mother got married before the child or the stepchild's 18th birthday. If you have domestic violence here in the US while you are on a work visa, will it affect your green card application by employment? So I would presume the applicant, ma'am, is the aggressor. If that is the case, yes, possibly. What visa po pwede i-file after reaching America through sibling petition? Didn't receive her green card, then she left America for 8 years. Tourist visa was denied because existing visa issued from sibling petition. Okay, so the first remedy that comes to mind is the returning resident, right? But kung 8 years na, it's been 8 years na hindi siya bumalik, you might have the returning resident visa. You only need to prove to the US Embassy that the reason why you are not able to come back are for factors beyond your control. Again, either because you are taking care of an ailing relative or there is war or calamity and so on. If you would be able to justify it for the last 8 years, then you may be able to apply for a returning resident. But if the returning resident is not an option, then again, the tourist visa was an attempt. Pero para hindi magiging rason, nag-immigrant visa pa rin siya, I would recommend that you file, i-return niyo yung green card sa embassy para may record na inabandon na yung kanyang green card status. So then reapply for a tourist visa and then explain to the embassy that you already have abandoned your resident status. Mayflower. Ma'am, at least sa pinned message ko sa Facebook, I recommend that you send a message to Nicholas Caraquel Facebook account. Kasi may mga staff na sumasagot doon, no? And if you send a message to me, ginagawan ko rin naman ng group chat. But I don't normally answer the initial stage of that inquiry. But I have 3 staff assigned to answer those questions. So I hope they would be able to answer your inquiry, ma'am. If not, mag-send ka na lang ng message sa iDream America. So we have 20 people who will be able to answer that question. Randy, if you're a J1 and on a fellowship program for a master's degree with a US university not in conflict with teaching, may ways ba na magamit siya for a waiver or mag-change ka into student visa? If you're a J1 and a fellowship program. So, isagot ko na lang to, boss, no? So, J1 visa in general, if you are subject to the 212E, you really need a waiver. And as of the moment, the only reason or ground to apply for a waiver, and we're going to talk more on detail of this next week, is if you have a U.S. citizen child or if you are married to a U.S. citizen spouse or a green card holder spouse. All other grounds could be difficult, right? Because now you're talking about sana magkasakit yung immediate relative. You don't want that, right? But if you're gonna talk about the common grounds of waiver, yun lang yung titingnan mo. If you have a U.S. citizen child or you are married to a U.S. citizen spouse or green card holder spouse. Other than that, it's really difficult to get a waiver. Ma'am Azuning, asa padala pa schedule. Ma'am, please send a message to I Dream America Facebook account and they will be able to schedule you. Okay? Okay, I'm about 10 minutes more. Hello, Ma'am Grace. Good evening. May Apostol. Hello po, Ma'am, from Rizal. VJ, what if nakasal si J1 sa isang citizen at subject to the 20E? Si J1, ano po ang best? Boss, I would recommend that the spouse will apply for the exceptional hardship, no? Kasi lahat ng mga nag-apply ng no objection statement ngayon are denied so far, right? Ma'am Shell, pwede pa send na lang ng schedule sa atin. Okay, guys, thank you very much for watching and for your all support. For next week, meron akong another Facebook Live, but this time is a very specific topic for J1 transitions, right? So whether it's J1 to H1B or H1B to green card or J1 to green card, we will be able to talk about risk, options, and waivers available for us to be able to do that. No, so it will be next week. I think Tuesday or Wednesday. So see you soon. Maraming salamat po. Good evening.